case briefs, and so much more. LSData's got what you're looking for.
In a compelling case from 1923, the National Association of Window Glass Manufacturers found themselves up against the United States Supreme Court. At stake was an agreement between the manufacturers, who were producing hand-blown window glass, that established a wage scale which limited the operation time of their factories. This agreement was deemed to infringe on the Sherman Act, which strictly prohibits businesses from restraining trade among states. Despite the apparent violation, there was a profound labor shortage in the industry, which led to the factories being undermanned and subsequently enduring significant losses. The manufacturers, in their defense, argued that the arrangement was much needed to not only secure employment for the working season, but to also equally share the labor force among factories. The lower court initially found the manufacturers guilty of contravening the act, issuing a ruling that prevented them from exercising any agreement that restricted factory operating times. Instead, they appealed, reasoning that their arrangement had no effect on interstate commerce, especially considering the fact that the handmade glass industry was competing against the machine production of window glass and was likely not to endure the test of time. The Supreme Court was thus forced to consider the specific circumstances surrounding the case, as per the precedent set in the Board of Trade of Chicago vs. United States. It examined the state of the hand-blown glass industry, which was already on the verge of collapse due to the widespread use of machines in window glass production. Ultimately, the court ruled in favor of the manufacturers. It agreed with them that the arrangement was both necessary and not an unreasonable restraint of trade. Thus, the Supreme Court reversed the lower court's ruling and dismissed the petition. The decision was made with the clarity that despite legislative measures to maintain competitiveness, there needed to be adequate exceptions considering industry-specific realities.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.